rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Thank you. Good afternoon. Welcome. Court officer, can you please call the case?
Good afternoon, Your Honors. This is case KC BC 2020-04, Specialist Prosecutor versus Pjetër Shala.
Thank you. Specialist Prosecutor's Office. Who is present today for you?
Good afternoon. For the SPO, Line Pedersen, Federica Genovesi, Gaia Pergolo, and Filippo De Mincis.
Thank you. Victims' Counsel.
Good afternoon, Your Honours. I'm Simon Laws, counsel for the victims in this case.
Thank you. Defence Counsel, you have the floor.
Thank you very much, Your Honor. We are here with Mr. Peter Shala from the detention center. I am Mr. Jelisen. I am here with my co-counsel, Mr. Edia Winnie. Thank you very much.
Thank you. And for the record, Mr. Shala, can you confirm that you hear me well?
Yes, Your Honor, I hear you well. Thank you.
Today, the panel will render a number of oral orders and directions organizing the presentation of the evidence by the defense. And we will give 3 oral rulings on requests pending before the panel. We take that opportunity to do that today. We start with the directions concerning the presentation of evidence by the defense. And the present directions are issued pursuant to Article 40, paragraph 2 and 6 of the law, rules 116, 119, 121, 141, 144, and 145, 153 and 154 of the rules. The first point, that concerns the defense's list of witnesses. The panel has taken note, after yesterday's defense preparation conference, of the updated summaries of the expected testimonies of the defense witness received yesterday by email at 14:46, and the SPO additional submissions of today, filing 624. At the outset, the panel notes that Rule 137 of the rules provides that the party may submit evidence relevant to the case, and pursuant to Rule 143, paragraph 4 of the rules, the questioning of a witness and presentation of evidence must be effective and avoid undue consumption of time and resources. And for the reasons that follow, the panel orders the defense to remove the following witnesses from its list. The first one is witness 4454. The second one is defense witness 404. The third one is witness 2517. The fourth one we want you to remove is 2549. And the last one is 4751, pursuant to Rule 119, paragraph 3 of the rules. Regarding witness 4454, he is expected to testify about the expulsion by Serbian police of persons from his village in March 1999, and that he was forced to flee to Albania. He was expected to testify inter alia also about his time in the KLA in Kukës, Albania, in April and May 1999, and that he went to the Kukës metal factory twice before going to Burel at the end of April 1999. At this point in time, I think it's better that we go into private. Madam Court Officer, can you bring us into private session, please?
Your Honors, we are now in public session.
Thank you. With regard to witness 4454, we note that this witness stayed at house 1 in Cucus and that he went to the Cucus metal factory only twice before the end of April 1999. And as a result, the panel finds that this witness' expected testimony falls outside the material and temporal scope of the charges, and that it will not assist the panel in establishing the facts of the case and in its determination of the truth. Regarding defense witness 404, who would be expected to testify about his times at the Cucus Mobilization Center in 1999, the panel finds that even following the submission of the revised summary, the defense has failed to show that the witness was at the Cucus metal factory at the time relevant to the charges. In other words, the defense has failed to show that the witness expected testimony that the accused was not a member of the 128 Brigade and that he, the witness, did not see the accused in Cucus is relevant for its case. Then we go to witnesses 2517 and 2549, who would both be expected to testify. and witness 4751 shall be removed from the defense list of witnesses. This is without prejudice to the panel, limiting the further number of witnesses later in the proceedings should it find their anticipated evidence to be repetitive or irrelevant. We direct you to file an updated list of the witnesses by Tuesday, 29 of August, next week, and the defense shall also file in the case record by the same date the revised witness summaries sent via email yesterday. Yeah? Thank you for that. Then the second direction concerns the time allocated to the parties and victims' counsel for the examination of the witnesses. The defense has indicated that it needs 48.5 hours to examine its witnesses. And following the removal of the 5 witnesses from the list, we find it appropriate to allocate 40.5 hours to the defense for the presentation of its case. And this is without prejudice to the panel revising the overall allocation of time should the evidence of some witnesses be introduced through Rule 153 or 154, or the panel finding that the estimates for certain witnesses must be revised. The panel expects the defense to respect the time estimates indicated for its examination of each witness and to inform the panel at the earliest opportunity if it needs less time than originally envisaged. If you would need more time, of course, that can also be the case, please seek leave from the panel sufficiently in advance. The court management unit shall inform the panel, the parties and victims' counsel via email at the end of each witness direct examination how much time the defense has effectively used, and at the end of each evidentiary block how much time the defense has used in total for examination of all witnesses called to testify up to that point. We allocate to the SPO for its cross-examination of each defense witness the same amount of time effectively used by the defense for its direct examination. And victims' counsel shall be allocated for his examination of each defense witness 25% of the time effectively used by the defense. This is without prejudice to additional questions being put by victims' counsel to elicit evidence for the purposes of the reparation proceedings. And should you require more time, you shall seek leave with the panel as soon as possible. And we reiterate our directions in paragraphs 20 to 23 of the decision on the conduct of proceeding, which is filing 534, and we recall our directions in 44 till 51 of that same decision. Now we go to the order of appearances of the witnesses. Defense, we order you to schedule at least 2 witnesses during the 6th evidentiary block. And in other words, you should add 1 or even 2 more witnesses to the witness you have already envisaged in order to be able to fill all days. That's we hope that you can endeavor, that you endeavor to do that. And please make all efforts to secure the testimonies of additional witnesses and liaise with the registry to this end. And as we said yesterday, consider also whether the video link can be of help in, and could facilitate the appearances of additional witnesses. You are required to file an updated order of appearance of witnesses for the 6th evidentiary block by Friday, 1st of September 2023. We have taken note of your order of appearances of witnesses for the 7th evidentiary block, and the panel directs you to file an updated order of appearances of witnesses 5 weeks before we have the next evidentiary block. And should the order of the witnesses change thereafter, due to unforeseen circumstances, please inform the SPO, the Victims' Counsel, and the panel, and the registry. Then the next direction relates to defense witnesses 3, defense witness in case for 3, and DV for 6. Regarding defense witness 403, the panel orders the defense to provide by Friday, 8 September, an updated CV containing more complete information regarding the expertise and qualifications of this witness, and especially the university of universities from which he obtained his degrees, because they are not specified at all in his report. He gives us a lot of information, but hardly anything can be verified if he would like to just check. The institutions in which he completed the additional training, from which he obtained the certifications mentioned on page 2 of his expert report, which is DPS 00865, and as well as any other relevant information that serves to substantiate his expertise and can be subject to objective verification. Then, with regard to defense witness 406, the panel notes that he is expected to testify that he was not in Albania from the 15th April 1999 until the 26th of May 1999. And it is a quote from the summary of the witness expected testimony. And the panel would like you, defense counsel, to be more specific regarding his whereabouts and to provide us with additional information as to where he was exactly through that time, including any supporting documents, as indicated in the updated summaries provided yesterday afternoon at the request of the panel. It would be important to have that on beforehand, so before this witness is called to testify, in order for parties, victims counsel and panel to prepare also on that point. Yeah? And I trust that you can obtain this information from the witness, and you shall provide this additional information by Friday, 1st of September 2023. Then we have the next point with regard to the video link, testifying via video link. And yes, that's the 5th direction, or away from the trial venue. The defense shall file any request for testimony to be conducted via video conference at least 5 weeks before the witness expected testimony, so as to allow for the necessary practical arrangements to be made. This does not apply for the witnesses scheduled, of course, for the 6th block that is upcoming. Should you decide, defense counsel, to call any of them via video link, you are directed to liaise with the registry and make a request to the panel as soon as you can. Yeah? But no later than Friday, 1st of September. And regarding the examination of witnesses away from the trial venue, although we noted your submissions that for the moment there is none, we direct you to our directions in paragraph 33 of filing 434, which is our conduct of proceedings decision. Then we go to the directions regarding the 153 and 154 rule applications. You have indicated that you intend to file applications under Rule 153 of the rules for witnesses 4405, 4441, for witness 4440, and for witness 3881. We order you to file any applications under Rule 153 of the rules for these witnesses. So, for the sake of the record, witness 4405, witness 4441, witness 4280, and witness 4440 by Monday, 11 September 2023, and for witness 3881 by Monday 18 September 2023, so in a staggered way. Applications under Rule 154 of the rules, should the defense decide to file any. We noted your submissions, of course, and we saw the change, but just in case, shall be made no later than 30 days prior to the testimony of the witnesses, and this will enable the SPO and Victims' Counsel to respond and the panel to rule on it in good time. Thank you. Yes, then the applications to summon witnesses, which is point 7, we order the defense to file any applications under Rule 121, paragraph 3 of the rules for witnesses 4405, witness 4441, 4280, and witness 4440 by Monday 11 September 2023, and for witness 3881 by Monday 18 September 2023. And Defense Counsel, a short explanation. We have decided to proceed in parallel with your Rule 153 and 121 paragraph 3 requests in the interests of an expedient and efficient trial. So should any of your 153 requests be rejected, then, and we should decide to hear the witness live, we need to be ready. And so that's the reason that we direct you to take the necessary steps in preparing your Rule 121 paragraph 3 request. Okay? And if you allow me, I make a short revision of this in court redaction order. Okay, very well. We proceed. Defense Counsel, we direct you to include in your request at a minimum the following: specific and sufficient information identifying the witnesses and their current place of residence, information showing that you have attempted and failed to secure the voluntary testimony of the witness and that the summons is necessary, and information showing that the expected testimony is material to your case. If the defense is not aware of the witness' current place of residence and is unable to obtain it, it may request such information from the SPO, and I see the SPO nodding, who may file the information with the panel on an ex parte basis, as also proposed by you already yesterday, available to the panel and the registry only, if need be. Yes, I see you also nodding, and that would make a flow of information to the parties or to the persons who need to know it. Yes, thank you. Then the 8th direction concerns the submission on non-oral evidence. We order the defense to submit any applications for the admission of non-oral evidence if it so wishes, and that also includes material pursuant to Article 37 of the law, as well as any other material, no later than Friday, 29th of September of this year. And we recall our directions regarding the submission of material through a witness, and we refer you to paragraphs 55 to 65 of the decision on the submission and admissibility of non-oral evidence, which is filing 461. Yes, and we also direct the defense to indicate by Monday 4 September 2023 which parts of item ERN DPS 00270 till DPS 00863, yeah, I'm sure you know what this is, it considers relevant, because now it's a very large document with a lot of interesting information, but we would like to know specifically what are the relevant parts you think. Very well. Our previous direction, that is for all of you, regarding the reclassification of transcripts following the completion of each evidentiary block remains in place. So we will continue with that too. This concludes our directions on the defense case. Then we will issue an oral order pursuant to Rule 119, paragraph 5 of the rules, concerning your request, defense counsels, to amend the exhibit list. Yeah, this is filing 618, paragraph 29 till 32. You seek leave to add 6 items which relate to witnesses 2549, 2517, and 4751. 4 items constitute prior statements of the witnesses, while the remaining 2 are reports signed by or related to these witnesses. And we have decided to reject the defense request, considering that all 3 witnesses have since then been removed from the defense lists, and therefore the prior statements are not relevant anymore. And the reports are equally not relevant to the charges, as they concern events that fall outside the temporal and territorial scope of the confirmed indictment. And this concludes the panel's ruling. Then we have a ruling concerning the request made by Victims' Counsel on the 17th of July 2023, where you seek the admission of non-oral evidence. This is filing 593. And this ruling is rendered pursuant to Articles 37 and Article 40, paragraph 6H of the law, and Rule 138, paragraph 1 of the rules. Madam Court Officer, can you bring us into private session, please?
Your Honors, we are now in public session.
Very well, thank you. A question to both parties and Victims' Counsel. At a very late moment, before we started our hearing, an email was sent to you with a request regarding your availability in the first week after the winter judicial recess. We have set the hearings for, in principle, for the 15th of January. But we would like to know about the availability of the parties and of Victims' Counsel for that first week. And we would be grateful if we could receive your availability as we speak now. So I will give you the floor, and if not, as soon as possible. Mr. Prosecutor.
Thank you, Your Honor. The SPO is available on those dates.
Thank you. Victims' Counsel.
Well, yes, we'll certainly be available.
Yes. Thank you. Defense Counsel.
So I'm afraid to have some problem, but I will try to check the possibility and to manage and to provide some information as soon as possible.
Yeah. Could that be on Monday?
Oh, I think it could be, yeah.
If it could be today, even better.
Yeah.
But if you could get back to the panel on Monday, that would be very much appreciated.
I will, okay.
Thank you.
Excuse me, Your
You have
Honor,
the floor.
just one extra element regarding these dates. Yesterday we have sent a request to the expert for the CV and other documents, and as we received your Honor's email, we have made the instruction and made the request for the availability of the expert for the different dates. Maybe we won't have a response for Monday, but we will do it as soon as possible. But this is something that we can arrange in the meantime. But as far as the team itself, by Monday, of course, Your Honors will have the information. And we are trying to work out the availability of the witness we expect to be on that block and update Your Honors as soon as we have information. But requests have been sent already on those new dates.
What I understand from your observation is that you were planning for the second week of January to hear this expert witness.
And the potential two other experts we are trying to consult with on issues raised and evidence submitted by the victims. So we are anticipating that the last block would be for experts. This is the way. We don't have any contact yet with the new experts, but for the one that we already listed in our list, we already inquired with him, and we are waiting for a response as to availabilities for those alternative dates. Thank you.
Thank you. Very well. I will make a tour to see if there is any issue the parties and Victims' Counsel would like to raise with the panel. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Nothing from us.
Thank you. Victims' Counsel.
Thank you, Your Honor. No, nothing from us.
Defense Counsel, is there anything you would like to discuss with the panel at this moment in time?
One discrete point, Your Honor, if you allow us, regarding the applications which go in parallel between Rule 153 and the Rules 121. Is it agreeable for Your Honors if we make those combined applications in the same filings, where one is the alternative of the other? Or would Your Honors wish to have two separate ones? There is an interplay between the rules in the current situation, so we can frame it in a way that if there is a rejection or requirement for them to appear, then in the same filing there is a prong that is alternative to the first one.
It's always dangerous to have different topics in one filing, if it comes to replies and responses and replies, I prefer to have two separate filings, if that is not too difficult for the defense.
Very well, Your Honor. We appreciate the guidance. Thank you very much.
And it has, for me, it has a lot to do with responses and replies. That we want to have different tracks and to have no confusion on what we are discussing in the different filings. Very well, thank you. Anything else? No? Good. Then we will resume the week of the 18th of September with the opening of the defense case. The exact date will depend on the new order of appearances you will be filing and which witnesses you can secure for that week. And I've heard that you will endeavor to give us a full week. The exact date will then be communicated in due course. And I saw that you were lifting your hand. Is there something you would like to add, Defense Counsel?
Just, Your Honor, to remind and put on the transcript as a matter of notice that if there is the addition of one witness, it will be the one that we indicated yesterday. That will be the one that we will be endeavoring to add, and I think it's DW401. If we succeed, that would be the one, as a matter of notice of who the additional witness could be for that sixth block. But of course,
would it not be possible to bring in any other witness? Because the gist of my request, to put it, the gist of my request of our direction is one or two extra witnesses, just to be sure that we can use that whole week.
I believe, Your Honor, if we add one more, we might run the risk of not having sufficient time for that week.
Yeah. It was more seen as a reserve witness, just to be sure that the week is full and not only one witness. So if it cannot be the witness you are foreseeing, that you would like to add, I ask you to look for another witness. And I don't want to bring problems to the order of witnesses you want to call, because there could be some kind of logic in the way you want to present your witnesses. But if it cannot be that witness you are foreseeing, and I urge you, and you are not held to do the impossible, like I said yesterday, to see if somebody else could be called. That's the guidance, the directions you will receive from us.
We will do every effort, Your Honors, and report by the 1st of September, as indicated. Thank you.
Good. Well, then we have come to the point that I thank the parties and Victims' Counsel for their attendance, and our interpreters for their interpretation. Thank you to the stenographer and to the audiovisual booth and to our security. The hearing is adjourned.
All rise.